Hello, everyone. My name is Sarah Soto. I am the moderator for our presentation today on arbitration versus litigation. Which forum better serves your business? This is an extensive subject, so obviously we're going to hit what we think are the important points for you to consider in connection with making a decision as to whether you want to have arbitration clauses and try to go that way with your litigation. If you have any questions during the course of the presentation, please do submit the questions. And if we have any time left at the end, we're going to address all of the questions that we can. And if we don't have time at the end, we will email you with our answers responding to your questions. So, as I said, I am a member of both the business litigation and the alternative dispute resolution practice groups. I've been a lawyer for more time than I'm going to admit, and I have had a substantial experience both in court litigation and in arbitration proceedings in various areas of representing various different businesses, including principally financial institutions and other types of corporations. And I have three very experienced attorneys with me here today. John Kincaid from our Texas office, Leo Peraza from our Florida office, and Lauren Pierce from New Jersey. And I would like to have each of them tell you briefly about themselves, briefly, mind you, even though we're lawyers, starting with Leo.
Hi, good afternoon, everyone. My name is Leo Peraza. I'm a principal with Bressler, Emery & Ross in our Miami office. And as Sarah said, my practice focuses on securities and commercial litigation. I have experience both in state and federal proceedings, and as relevant to today's topics, I also have substantial experience in alternative dispute resolution, arbitrating primarily securities and commercial disputes before FINRA, the AAA, and the ICC over the past 10 years. And with that, I'll turn it over to my colleague, John Kincaid.
Good morning, good afternoon, everyone. John Kincaid. I could repeat what Leo just said, but not do it as well as he did. But my practice is within the financial securities and commercial litigation. I practice within securities, litigation, and arbitration, and also commercial trial and arbitration disputes within financial services and general commercial disputes.
Good afternoon, all. I'm Lauren Pierce. I am a principal at Bressler in our New Jersey office, predominantly practice in the Northeast with an emphasis on New Jersey, New York, and Pennsylvania. In federal and state courts, I am a member of our business litigation practice group. Most of my work is, this will come as no surprise, I'm the lone focused litigator here. I do have a lot of experience with commercial litigation, employment, construction, fraud, quite a varied background in both the trial and appellate levels.
Thank you all. And now to begin with, we just briefly wanted to acquaint you with 4 decisions from the United States Supreme Court over the past year or so that I think have established or taken care of some issues that were sort of hanging out there and tied up some loose ends. The first would be Badgerow versus Walters. This is a March 2022 Supreme Court decision. And it established that when considering a motion to vacate or to confirm an arbitration award, a federal court cannot find jurisdiction by looking through the motion back to the underlying dispute. In other words, if the petition itself does not show that there is either federal question jurisdiction or diversity jurisdiction between the parties with the correct jurisdictional amount, etc., you cannot move to vacate an arbitration award or move to confirm it in the federal court. You must go to the state court in order to accomplish that. The Supreme Court also decided Morgan versus Sundance. That was in May of 2022. In that decision, the court held that it was not necessary for a party to prove prejudice in order to establish that the other party had waived the right to arbitrate by engaging in litigation without asserting arbitration for X period of time. That was a very popular case, and a lot of people wrote about it like it was a big deal. Personally, I don't think it was a big deal, because for people that regularly practice in the area of arbitration, it really behooves you to assert your right to arbitrate at the earliest opportunity once you are there, because it has always been the case that if you do not do that right at the beginning, you are vulnerable to someone finding that you have waived that right, because arguments of prejudice are, available in a lot of situations in which people do not assert those rights. The third case, I think, of importance during that time period was in June of 2022, and it was the Viking River Cruisers versus Moraina decision. What this case did was reaffirm once again the court's commitment to the Federal Arbitration Act. It held that California could not essentially could not forbid someone from dividing their claims into individual and representative claims, because that would, of course, deprive people of the ability to engage in arbitration. So the court once again expressed the commitment that it has made for many years of encouraging and enforcing arbitration agreements as set out by the parties. And finally, we had the decision back in June of this year in Coinbase versus Bielski. And in that case, the court took care of the issue of stays pending the appeal of decisions denying motions to compel arbitration. I do think that was an important case, because although generally the courts did stay litigation pending an appeal of the denial of a motion to compel arbitration, sometimes courts did not. And it seems fairly obvious that if you've entered into an agreement to arbitrate, and one of your motivations almost always will be cost and efficiency, you sort of lost all that if you have to keep litigating in court while your appeal from the denial of your motion to compel arbitration runs its course. You probably will take, a year and a half, if your court is efficient and you are efficient. So by then, you'll have been through a lot of expense in terms of litigating the case in court. Those were the principal decisions from the U.S. Supreme Court in the past years, and I would say that essentially, without variation, all of these decisions and all federal courts continued to enforce the principle that arbitration agreements are enforceable in the way that they're drafted by the parties, with almost no exceptions. There are some, but they're not even worth mentioning for the purposes of this particular presentation. And that therefore you have a tremendous amount of options and freedom available to you should you choose to go the arbitration route, in terms of framing the way that you want the arbitration to go. Now, as I think most of you probably have thought through, there are advantages and disadvantages to going to arbitration, and there are advantages and disadvantages to staying in court. And depending on the nature of your business and what is important to you in terms of those advantages and disadvantages, then that's the place to make a contractual choice for your business. Some people favor one, other people favor another. Some people are equally comfortable in both. And to discuss the various issues that you want to consider before you make a decision, I'm going to leave you in the capable hands of Leo and Lauren.
Sure. Thank you, Sarah. So, to facilitate the conversation here, Lauren and I are each going to advocate for one side that I think happens to mirror our own personal preferences conveniently enough. I'll be advocating for essentially the pro arbitration side, and Lauren will be advocating for the pro litigation side. So I know most of these pros and cons are familiar to you. I know we have a lot of practitioners on the call, so we'll kind of work through them. Many will overlap, and we'll just have a free-flowing conversation with Sarah to keep us on track here, I'm sure. So as Sarah mentioned before, oftentimes cost is really the first and foremost priority for individuals who are making this decision. I'm sure Lauren and I will have different views on many of these factors. However, this should be one that I think we'll agree on at least. Generally speaking, arbitration is significantly cheaper than litigation, as Sarah mentioned. While arbitration forums typically cost a little bit more on the front end in terms of filing fees, they more than make up for it in the overall cost of discovery, motion practice, and even the final hearing. I think one of the main drivers of this cost savings is the more limited discovery provided for in arbitration, which we'll go into a little more detail later. Depending on the forum, on the arbitration forum that you're in, you may not have depositions, for example, or a very limited number, and also limited written discovery, typically few to no ROGs, requests for omissions, and the like. I think one interesting and good example of this is the FINRA Discovery Guide. For those of you not familiar with the Discovery Guide, FINRA in its infinite wisdom, after years of discovery disputes, created essentially a standardized first request for production that goes by rule to both claimants and respondents, and which identifies presumptively discoverable categories of documents. Of course, parties are free to propound a second request targeting unique issues in their case. However, they tend to lead to reduced motion practice and a certain degree of predictability in discovery. For those of us who frequently practice in the forum, you know what documents you're going to be expected to produce and what documents you'll receive, right? I think it's worth noting here that arbitration has, over the past few years, undergone, I think, what they refer to as judicialization, right? Where it's increasingly looking more like a full-throated court litigation. We may talk about some of the reasons for that later on, which I think include hostility to the forum, increased institutional participants, and more participation by litigators. These have increased the cost somewhat, but arbitration continues, I think, to be the preferred forum when it comes to cost effectiveness.
I, as the litigator, will tell you that litigation, generally speaking, whether you're federal court or state court, has a very clear roadmap, I think. As Leo pointed out, FINRA now has more of a roadmap than it used to, but not all arbitration is FINRA, and some arbitrations that are not in the FINRA world do not have the same clear roadmap that you would get in litigation. I do agree that even though the upfront costs on arbitration are high, much higher than going into the courthouse, costs when you're litigating in court, generally speaking, can be much more substantial, but the end result, if you're in an arbitration, could be significant, the end result, if you don't win. Whereas in an end result in a courthouse, you have the right to appeal. So overall, the costs could really balance out. And depending on, every litigation is different, depending on the litigation, there may not be as many depositions. There may not be as much motion practice as, some of the larger, more complex cases bring to the court. But yeah, I do have to agree with Leo that the costs are generally cheaper in arbitration, except potentially at the end of the day when you're stuck with an arbitration award that you cannot appeal, that you feel has been unjustly made. So, upfront costs overall will be higher in litigation than in arbitration.
Thanks, Lauren. So moving on down the list, essentially to help you follow along with us, we'll get to the appellate review, which Lauren mentioned early on, and the finality or limited review of arbitration awards. So as to the scope of discovery and arbitration, yes, discovery and arbitration is more limited. But I'm not really convinced that it's much more meaningfully limited. I think the primary weakness of arbitration that I typically hear from litigators is, you don't get your 5 to 10 depositions, 30 interrogatories, and requests for admissions. That you're essentially limited to document production. Somehow I think that the argument is that it puts you in a disadvantageous position of not knowing everything there is to possibly know in advance of the final hearing, or having examined every witness that you'll face at trial. But I'm not really convinced that this type of discovery materially changes the outcome, right, in terms of the merits to justify the tremendous cost that it incurs. I just find it difficult to think that, let's say, after an adverse result, you think to yourself, well, if I had that extra deposition, it would have been a totally different outcome. I don't think that's really the case. I think we can also look at this issue from another perspective. Many of us represent institutional clients who are typically sued by the individuals. I think the real risk and cost of broad discovery, which is permitted in court litigation, is really the onus is on us and our clients, right? So I would argue that the more limited scope of discovery and arbitration really, in a sense, favors us, right, from a breadth and cost perspective. I think we've all been there where individuals are seeking, for example, extraordinarily broad e-discovery from a corporate defendant. And arbitrators are typically trained by the forums to seek a balance between relevance and cost. And in my experience, they do a pretty decent job. Or consider the challenges and cost inherent in preparing a corporate representative for a depot, right? And you almost entirely avoid this issue in arbitration. Overall, I think as to scope of discovery, arbitration strikes a pretty good balance between what is necessary in discovery and cost, such that it makes it the preferred forum from this perspective as well.
And on the litigation front, when you are looking at your scope of discovery, generally the court rules, whether you're in federal or state court, will give you a significant amount of guidance. You're going to get the right to serve interrogatories and potentially supplemental interrogatories if something comes out that it changes things and that you need to pursue later in the case. You're going to get document production. You are going to get depositions. Federal court is generally more limited than state court. But if someone is overreaching and getting out of hand, you have the right to go to the judge. Generally speaking, in the federal court, the magistrate judges are very much available and will help narrow the issues for discovery. So the scope is not, some are very fearful that, courthouse litigation is, soup to nuts and that anyone can ask anything they want. And that is generally not the case. The judge will limit if there is, an overreach. Also, in my experience, taking the depositions is very important. You can zero in on the most important witnesses in your case very quickly. And you can often take a deposition which will potentially change the course of the case, and it could very well narrow the issues for trial, narrow the issues such that you can move for partial summary judgment, full summary judgment. Dispositive motion practice can result after a couple of depositions are taken, whereas in arbitration, once you're in there, and if you don't get that many depositions, you're very limited. Also, I use, and many practitioners use the depositions as in essence a vetting process. Oh, the other side's expert is extremely weak, unable to really answer difficult questions during a deposition. I can't wait to get him on the stand, or that it helps you actually negotiate a resolution faster, that you may not ever step into trial into the courthouse because the adversary's expert or the adversary's lead witness has appeared to be weak during deposition testimony. So coming from a litigator's viewpoint, the court will rein in anyone who's run amok with their discovery requests. But I do think you can narrow your issues significantly with the aid of the judge. Keep your costs down and really get your case ready for trial if you need to, because of the ability to take certain kinds of discovery in a courthouse litigation versus an arbitration proceeding.
I think that point you raised, Lauren, is usually one of the more interesting conversations that, we as arbitrators have with experienced litigators, relating to your opportunity to examine a witness previous to trial during a deposition, right? There's some, in our experience, I typically have found, who's going to be the key witnesses, who are going to be, what the key issues are going to be. You get a trial run at them. But I think the inverse is also true, that they get a trial run at you, right? You know how they're going to come at them, right? You know how you're going to prod certain issues. They get to prepare for you. And by the time that you're at the final hearing, they're better, they're refined, right? And I think that that's important. In our experience with securities arbitration, and typically, generally, especially for lay witnesses, without a depo, when they're raw at the final hearing, on the spot, nervous in front of arbitrators, first time you're going at them on documents and cross, I find that it's very, it's a very powerful way to test their veracity and their strength as a witness, even if ultimately, they're good, they have good facts behind them. Just something about never having gone through that process before is a very powerful way to shake, especially an opposing witness. Experts, I understand that, especially technical issues, but you have your own expert witness. They take a look at the documents. Where you can come at them, where they're vulnerable, where their methods may have been questionable, right? So in my experience in the arbitration, so much of that prior proceeding is not, it's helpful, sure, I'm not going to dispute that. I just find it to be a little bit overstated in the litigation versus arbitration, discussion.
I don't necessarily disagree with you, but I have pulled a rabbit out of a hat, so to speak, after some depositions. Recently, I just settled a large case where the expert was not as prepared as he should have been, and the other side came to me very quickly after that first day. I had a second day scheduled, and you better believe I was ready to really go to town on him on day two. After our day one, he conceded so many things. I was thrilled. So and actually we ended up achieving a very good settlement for our client after that deposition. So it does cut both ways. I agree with you, but sometimes those depositions really are key to getting an early resolution, as opposed to a lengthy trial, or if you're in ARB, if you can get a deposition, that might be helpful. But discovery in litigation can often really form the rest of the case and narrow it if necessary.
Yeah, I think this is a topic we can talk all day on, and I know John Kincaid is eagerly waiting behind us. So, so moving on. Privacy, I think, is pretty straightforward, right? I think, in my opinion, this is another big check in arbitration's corner. Proceedings and the awards are typically entirely confidential, right? Unlike court litigation. I think, the only limited exception that I'm aware of is FINRA. When an award is rendered, it's publicly available, right? But I think, have you ever seen a FINRA award? I think the narrative and the information provided are somewhat limited. So I think generally the privacy of arbitration is something, I think especially corporate clients that may have sensitive issues, is definitely something that when they're weighing the pros and cons that we're discussing here, would certainly, I think, tilt them as a pro in favor of arbitration, certainly.
Agreed, but there are plenty of cases that we've all been involved in where protective orders are issued when there's, specific information that cannot be made public. You can get a confidentiality order. The courts are, I say, more restrictive than they used to be on issuing those orders.
Mhm.
And certainly it is highly unlikely that the outcome will not be public. But you can keep discovery, certain kinds of discovery, if not all, under wraps, depending on the subject matter, as long as the judge, agrees with you and will issue the appropriate order.
And this may also vary from state to state. In the state of Florida, it's very difficult
Right.
to have anything kept out of the court record. Very, very difficult.
Same thing in Texas. It's next to impossible to get it sealed. It does happen, but it's more difficult.
Right. Usually if there's a minor involved, it can be sealed, but yes, keeping something sealed, but they will allow you to keep, intellectual property. There's obviously a large swath of topics that the courts will agree. Employment issues sometimes are kept, obviously, very specific. Sometimes it's very fact specific to the individuals involved in the case, medical information, things like that. But yes, I agree that the arbitration proceeding is largely going to be kept private, which will sway many corporations to go that route.
I think this kind of leads into the next bullet point here, the ability to define and customize. And I think John's going to have a full slide dedicated to this, maybe even two. But, suffice to say, I think since arbitration is typically a function of an agreement between the parties, the parties have pretty wide discretion in customizing the proceedings. I think this includes identification of the forum, substantive law, even procedural elements of it. I think this is especially helpful in agreements between two sophisticated parties who are in a position to kind of assess their respective risk levels and the best avenues to mitigate the risk while maintaining the cost effectiveness that we've talked about here. I know John's going to go, I think, into more detail on that.
Right. Yeah, I totally agree. And I do believe John has got some more to raise on that.
And duration of the proceedings. I mean, I think this one's pretty straightforward as well. Typically in arbitration, you will have a final hearing within 9 to 12 months. Most forums will also provide, I think, expedited schedules in the event of elderly individuals or infirm parties where you can get a final hearing even as quickly as 6 months. I think this is substantially quicker than the kind of ETA in court, where you're looking at a trial probably on average 18 months after the filing of the complaint, if that.
Boy, you're an optimist.
And he's also not from the Northeast, which is still trying to catch up after the COVID shutdowns. The backlog up here is generally very significant. But while it takes, on the duration of proceeding issue, while it takes longer, generally speaking, to get into a courthouse for trial than in arbitration. I have been involved in arbitrations where, you might go a week and then you need another week, or you need multiple weeks, and it's hard to get those follow-ups scheduled. Whereas the court, generally speaking, unless you've got a bench trial, once you start your trial, you're going through to the end unless you settle. So, again, there's two sides to this issue, but as far as getting there immediately faster, yes, you would in arbitration, but you may not finish ahead of a courthouse litigation.
Fair enough. So I think the next topic is also an important one when it comes to this conversation and the assessment. The importance of more rigorous application of applicable substantive and evidence law. From my perspective, I think arbitration has obtained somewhat of an undeserved reputation on this, probably promoted by litigators who don't like the forum, of being, the Wild West in terms of substantive law and or evidentiary law. which I don't think necessarily reflects the reality on the ground. I think as to substantive law, I do find most arbitrators do try to follow the law, right? They may do so in a manner a little more informed by equity, but I don't find that it ever results in a materially different outcome, right, than what the law would prescribe. I think it's important to note here that most arbitrators are professional arbitrators, right? Parties put a lot of time on the front end evaluating and ranking potential arbitrators. FINRA, for example, has a list of chair qualified candidates, which reflects additional experience and training than your typical panelists. So I think they're generally very capable professionals who care about doing a good job and want to rule correctly as a matter of law, and while balancing the desire to impart justice on the facts of the dispute. I think, as to evidence, yes, obviously there's a certain element, a certain degree of truth that during the hearing, a chairperson will typically permit evidence that may not necessarily be admissible in a court, right? And in response to an objection, you can typically expect the chairperson to say, the panel notes your objection and we'll give it the weight it deserves, whatever that means. I think typically this is done by the panel, probably under a misguided impression that anything they exclude or the exclusion of any evidence may result in a vacator of the award. I don't think that's accurate, but I think that's what motivates some of that decision. But again, I think the arbitrators do understand the reasons behind certain evidentiary objections and do impart different weight and credibility on the evidence. If, for example, it's hearsay or does have authentication problems. So again, this is, I think, another area where there's a difference between litigation and arbitration, but I'm not sure or convinced that it materially affects the outcome sufficient to outweigh the other advantages that we've talked about. And, let's not suddenly pretend that rulings on either substantive law or evidentiary issues in court are always perfect or correct either.
Yeah, and if I may throw in on that in terms of the arbitrators, you cannot do this, for example, at FINRA that I know of, but you can do this at the AAA or at JAMS, which is that if the parties agree that their case involves a particular area of law or commerce that would benefit from evaluation by an arbitrator with particular expertise, the AAA will try to find such arbitrators for you from their roster. You can actually, assuming that your opponent agrees with you that that expertise is needed, you can actually get yourself an informed and experienced arbitrator in particular areas.
And even too, Sarah, within, although I wouldn't be arguing necessarily for arbitration, I have had panels come back and say that they want to retain their own expert, which then pushes back on the parties to pay for that when typically the two parties have already, put forward their two experts. But that's something that can happen in arbitration as well.
So I think you all will know my viewpoint before I even say it, but in my view, this is the strongest or one of the stronger reasons to go to the courthouse to litigate. You've got a body of case law, unless you have a rogue judge out there who should be worried about an appellate court. They're going to apply the law. The body of rules of evidence is very important. You also have the ability to file motions in limine in advance of trial if you think that there's a tricky evidence issue. Obviously, evidence issues come up at trial all the time, but very critical ones you can get decided in advance, bring it to the judge's attention, and then pretty clearly all your major evidence issues, how they're going to play out before you step foot into that courthouse for trial. So what's coming in, what's not coming, going to come in, and generally speaking, the judges do a very good job at applying the evidentiary law, and I couldn't have agreed with Leo more that it is a bit of the wild, wild west in arbitration on evidence and substantive law. So because the trial judges are, very concerned about what an appellate court is going to say about how they've interpreted the law. So they're very concerned and get it straight a lot of times.
I think this feeds into the next topic that we have here a little bit, the availability of motion practice. Yeah, I mean, as Lauren started to allude to, motion practice, I mean, is more limited in arbitration, but it's still available, right? I think, for example, in FINRA, there are very limited grounds to dismiss a dispute that's just been filed. Things like the statute of limitations are not among them, so you have to wait until a party presents their case in chief, typically, which is not optimal. However, I know in the AAA, I think JAMS as well, you are permitted to file summary judgment motions and a broader array of motion practice. Typically, they follow a little bit of a different procedure, which I think is also interesting. Before filing and fully briefing your motion for summary judgment, you file typically like a notice or a letter to the arbitrator, to the chairperson, essentially setting forth the basis that you think for summary judgment, that you have, a good high probability of success and the reasons why. And essentially the arbitrator will have to grant you leave then to file the motion for summary judgment. So I think that's an interesting and I think a very efficient way to eliminate some of the frivolous motion practice. In court, I see every other case, folks file a motion for summary judgment, assert there's no undisputed material facts. And, I think it's apparent that it continues to be the case. Nevertheless, you have to go through the briefing. But I think this kind of middle ground that's available to you in arbitrations is a very smart way of doing it. And really, it avoids this kind of motion practice that only serves to increase the cost. So I think arbitration, yes, more limited, but it does a nice job of balancing the appropriate motion practice.
And as I mentioned before, motion practice can really narrow the issues for trial, bring the case to a faster resolution, less costly. Again, the courts, generally speaking, are careful about having a wide, expansive discovery. They tend to balance it very carefully, I think. So, I think the ability to bring a motion when your adversary is out of line or when something has become very clear from discovery, bringing a motion early to shut down the litigation is very important, and you may not have that option at all in arbitration. So I do think this is another strong reason to litigate over arbitration.
So next we have the jury versus arbitrator dispute. Arbitrators are essentially judge and jury all rolled up into one, right? Typically, you'll have a panel of 3 individuals who generally have to reach a consensus on most issues. And as I've mentioned before, typically they are experienced professionals. I think often business or commercial litigators themselves, and people who care about the subject matter of the forum, right? I think another factor is that the arbitrators are typically trained by the host forum, right? For example, I think FINRA will train their arbitrators on securities issues, the types of disputes they can expect to see, and other, specific industry-related disputes. I don't think poorly of juries at all. I think quite to the contrary, I find that most of them are also trying to do a good job and apply the law and find a just outcome. So I don't really see any advantage necessarily in having a jury over a panel. But on the contrary, I do tend to personally appreciate that arbitrators are professionals with some background in the subject matter. And to add to that, we as parties typically have a fair amount of say in the initial selection of the arbitrators. So I think on balance, I think the selection of the panel, I would tend to prefer over having the jury.
And jurors, as we all know, it's a jury of your peers. So some will be potentially
not necessarily.
Some will be highly educated and some maybe not as much. But I do think, I honestly cannot think of a case that I have tried where I thought the jurors were not paying attention. I've never had to like drop a stack of books to wake somebody up. I don't know, maybe I have interesting cases, but I think that jurors take it very seriously. And if in the event the jury, this spills right into our next bullet point, if the jury makes a mistake, you do have the appellate review in the ability to take a matter up to appellate courts. And to me, that trounces any participation by, a very seasoned arbitrator who has a lot of knowledge of the subject matter. The ability to go to the appellate courts if there is an error conducted in trial is very significant and very important to parties. It can save the day, so to speak.
Yeah, so we'll jump to the appellate review bullet here. And I mean, yes, generally speaking, that's correct. Review of arbitration awards is by and large extremely limited. But as I like to call this topic, rather than appellate review, arbitration has the additional benefit of finality, right? As any litigator knows, a challenging case can go up and down on appeal, raking up costs, delaying trial for months, etc. Your client gets a good outcome at trial, here comes an appeal, right? And on and on. Our arbitration doesn't suffer from that, right? An award, absent pretty extreme circumstances, is final. And I think there is a lot of value in that. As I noted before, these are professional arbitrators. And I think an important factor that gets overlooked in this discussion is that many of them are repeat arbitrators in a forum, right? And in order to stay on rosters for forums and not get stricken by parties, they can't go off the reservation. So I think this notion of a rogue arbitrator that we've kind of alluded to a few times here is more of a boogeyman than like a real and present danger here. Of course, it can happen. I don't think the probability of that happening is significantly higher than the probability of a rogue jury, for example. So again, I think on balance, the benefit of finality, especially for large institutional clients who have frequent litigation, I think outweighs the risks here.
So if you're in the courthouse, not only do you have the trial judge instructing the jury throughout the case, who, generally understands the rules and the body of law involved, and he or she, generally speaking, gives very wise instruction to the jury. He or she, the trial judge, also at the end of the case, has some ability to alter a rogue ruling by a jury. And then you often have an intermediate appellate court as well as a, the highest court would be also willing to, generally speaking, review your matter. So for me, I do understand that you would not get the finality immediately, but the vast majority of cases that are tried do result not in going to the appellate court. And also there's an opportunity, if there is a rogue ruling and the parties figure that out very quickly, then they can resolve it potentially. Whereas, in arbitration, because of the fact that there is such a highly unlikely chance of appellate review, that ruling is going to stand, and there's not going to be an attempt to resolve it if there's an error in the arbitration proceeding.
And so on that note, I think John Kincaid is going to get a chance to tell us something regarding the considerations for your arbitration agreement. And you're going to get your first CLE code. I'm sorry that took so long, but your first CLE code is forum. Sort of makes sense, right? In what we're doing here. And with that, John, if you would take it away, please.
Absolutely, Sarah. Thank you. And Leo, can I get you to pop to the next slide? We'll come back to the different forms, but just in terms with the limited time we have, if you are going to focus on arbitration, and that's where you as counsel want to advise your business clients, or that's where the business feels most comfortable from an institutional perspective, then there's going to be some really key provisions that you want to focus on within your arbitration agreement. And the one thing that, just following up on that great discussion between Lauren and Leo, the other thing is that if you're not sold on arbitration, and for whatever reason you have concerns about trying a case, expense, whatever, to a jury, you can also always include a jury waiver in your contract, and then you are going to try that case to the judge, who is going to make those findings of facts and rules of law and going to make the determinations of the legal disputes and the factual disputes. So that's one alternative. But if you're going to go within an arbitration, that's where you want to go. I would throw out a couple of things that we want to hit here. First is the location or the locale. It doesn't sound like that's really a big issue, but if you're already at loggerheads with the other side, then you want to have established what city, county, however, where that arbitration is going to occur, so that you're not fighting about that. Because if you are fighting about it, then the forum's going to step in and make that decision for you. And so that's something that you want to knock out. The other thing you clearly want to have in the arbitration provision, in addition to the larger contract, is a choice of law provision. You want to say that the arbitration and the award will be determined under the choice of law or under the applicable law of the state of, without relation to or consideration of choice of law, because you don't want it transferred to another state's law. So you're really going to want to have that, and that's going to be important. That's really going to be driven by a lot of what things are in your contract that is favorable in a particular forum, and that's why, or a particular state, that's why you have that law in your contract. Then you want to repeat that in your arbitration clause to make sure that that law that you're relying on in your contract is going to be applied in your arbitration dispute. The next thing is severability.
And also, just to add a little finer point on that, you also, if you want to make it clear, you need to put down that your arbitration is going to be governed by the Federal Arbitration Act, so that there doesn't have to be any time wasted as to whether something was or was not preempted by the state law.
Absolutely, absolutely. It's a great point, Sarah. The next is severability. What I would say there is keep the baby when you're throwing out the bathwater. And you're going to have a severability clause within your contract, of course. I think the better practice and the best practice is to include within the arbitration provision or the arbitration clause of the contract a severability provision as to any offensive terms within the arbitration agreement itself. So I think you want to have two places where you include severability in the contract, and then also within that arbitration provision. Another thing that's vitally important is scope. Do you want it to cover specific disputes or specific matters only under the contract? Or you'll see oftentimes with financial institutions or those on the security side, it's going to say any disagreement you have with me. And so you need to go in deciding what is going to be arbitrable or not, because if you have a broad scope, most courts are going to default and say, we're going to send most anything to arbitration. But if it's a more limited scope and there's an argument that this dispute falls outside of that limited scope, then while you may want to have been in arbitration, you might find yourself at the courthouse. Other thing, scope of discovery. Both JAMS and AAA, for instance, permit discovery, but depositions are not a guarantee. And so if you think you're going to need depositions, you may get them in arbitration and you may get them ordered, but there's going to be limitations as to time, as to scope, as to how many. You're going to have more opportunities under court. So decide in your arbitration agreement, if you can, You want no interrogatories. If you want an automatic production of documents, you want to take a look at some of those things. Look at what the forum provides that you are intending to go into, and then see what you want to supplement or change about that forum's discovery rules. The next thing is dispositive motions. Yes, they are allowed in arbitration, within a summary disposition within AAA. It's going to be the arbitrator. You have to ask the arbitrator for permission to file that summary judgment or other dispositive motion, and point out to the arbitrator and have them rule that, one, the motion is likely to succeed, and the motion will dispose or narrow issues in the case. So you're going to have to think about maybe a 2-pager, something that outlines why it should be granted, why it's going to be successful, and why it's going to narrow the issues. So that's going to be what you see in the arbitration forum. If you clearly want a summary disposition under the federal rules, for instance, then you may want to say that to make that clear relative to dispositive motions. You need to look at what the standard for the award is and the evidentiary burden. Go back and look at what's in JAMS and what's in AAA, because those arbitrators are allowed to award relief, any remedy or relief that the arbitrator deems just and equitable within the agreement. That is not bound by the rules of law. That is not bound by rules of evidence. That's what the arbitrator believes is just and equitable within the scope of the agreement. Sure, within arbitration, you're going to be arguing rules of law, but at the same time, you're going to be pointing out to the arbitrator the policy and the reasoning behind why we ended up with that statute, or why we ended up with that particular common law rule. But otherwise, if you want it by under rules of law and rules of evidence in a AAA forum, you're going to need to specify that in the agreement. Within JAMS, it's the same thing. JAMS says we will follow the rules of law agreed upon by the parties. You want to do that on the front end, because again, once you've hit a dispute and it's headed to arbitration, it's very unlikely that the two sides are going to agree as to what law applies and rules of law, although they might, because if you don't, then the JAMS arbitrator is going to have the same ability to make a decision on the basis of what they consider to be just and equitable. Then you want to determine, do you want to have a reasoned award? Do you want an award that explains what has occurred, what the factual findings are, and what the actual decision is, applying the law or the equities or what is just to the facts that the arbitration panel has found? I think that's important to include that with it. And then I would talk a little bit about
on that one.
Absolutely.
I'm going to disagree. On that one, I'm going to disagree. The ideal award is we find for X in the amount of 0, or dismiss all other claims.
Sorry about that.
Or we fight for X in the amount of such and such, and dismiss all other claims. Maybe some recitation of what went on. But once, to me, the whole point of arbitration is to get to an efficient result. As you multiply things that the arbitrators have to do, you are reducing that efficiency. As you require them to expand upon their thought process, you are increasing the very limited, admittedly, possibility that a state court, for example, might decide the award should be vacated for reasons X, Y, and Z. And I realize that this cuts both ways. But I think one of the main reasons that so many institutions chose to arbitrate is precisely because of the efficiency and the cost benefits of that process. So yes, you can and should cover anything that helps your business in particular. A reasoned award is highly unlikely to be one of those things.
Sarah, I do agree with that analysis and breaking it down, because I very much agree with one thing that Leo said earlier about the process. What I have found in AAA and in JAMS, even though it's written into my party's contract and it's standard in all of these contracts, when we get into it, you're often approaching it as if it was just a private courthouse, but going at the whole thing and losing that speed, losing that informality and the elasticity that the process is supposed to bring, loading up, asking for interrogatories, loading up, asking for depositions. And so before you start bringing it, if you're working for an institution or defending it for an institution, commercial organization, whatever, you've got to have that conversation with your in-house counsel partner and say to her, to him, do we want to approach this like a trial, or do we want to really approach this like it's a arbitration and have the speed and have the other informalities that are associated with it? And then, of course, you got to get the buy-in from your business people on it, because otherwise you will turn it into a courthouse proceeding that is just happening in a conference room that you're paying for the room and the hourly fee of each of those three lawyers sitting up there as your judge and jury.
And by the way, this is, efficiency is a good thing for both sides, probably.
Absolutely.
I mean, the defense generally thinks of it more because it tends to experience more repetitive litigation than an individual bringing a claim does. But efficiency and a lowering of cost and a narrowing of discovery to the truly relevant issues probably benefits everyone, both claimant and respondent.
Right. And I see that we're quickly popping out of time. So I know we may want to address some questions or something, but you want to look at your agreement, the allocation of the cost and the fees, because the forums will make that determination if you haven't said whether you want that to be allocated and awarded, and including fees and not just the cost. Because if you don't say something, the forum will, and it'll be a part of their rules. If you're going to want a right to appeal, you really ought to think about whether you're wanting to be in arbitration or not. But if you want to, it's going to be what jurisdiction does your appellate choice particularly have over the matter, and what's going to be your standard of review? Is it going to be de novo? Is it going to be abuse of discretion? De novo, you're just going to, why not have a trial, in the first place? Again, look at the forum rules, pick and choose which of those rules you want to modify within your agreement, and then always pick a backup forum. It's kind of like, don't laugh, it does happen. It doesn't happen often anymore, but I don't think JAMS or AAA are going anywhere. And some courts have made some silly decisions like, gee, NASD is no longer there, so it's FINRA now, so you don't have a forum. That stuff tends to get handled on appeal, but those are just some of the things. And I know we want to see if we have any questions, and I know you've got
one more point that I also did want us to emphasize from the standpoint of the availability of emergency relief. Most forums at this point do have a mechanism for seeking emergency relief. I think you will find that none of those mechanisms will work as well as going over to see the judge with a TRO and see if he'll enter it, okay? It's just not as fast in terms of being reactive. And in some businesses or in some areas of the law, the availability of emergency relief is crucial. I mean, for example, in cases involving restrictive covenants, if you have to go through some lengthy procedure before a restrictive covenant is ruled upon, you may already suffer damage that you cannot correct thereafter. So think about how you want to deal with any emergency relief things that you might have. And with that, we have, I think, run out of time. So it's time to give you the second CLE code, which you are shocked, since Leo is the one that pulled it off, is arbitrate. The first code was forum. Second code, pardon me, is arbitrate. And with that, thank you all so much for your attention. And again, if you have any questions, please submit the questions and we will respond to you by email. I am sorry that we were not able to respond during this yourself. Have a good day.